A very warm welcome to lesson number 25 in our 50-part series on the law of evidence. In today's lesson, we will be taking forward our discussion on admissions. Therefore, it's very important for you to first watch lessons 22, 23 and 24, wherein we have already discussed admissions to some extent, before you start watching this lesson. You can access those lessons by clicking on the I button on the top right of your screen. With regard to admissions, sections 17 to 31 deal with admissions, and as you can see here, I have omitted the part from 24 to 30 because 24 to 30 deal with confessions. Confessions are also admissions, but I have omitted it here for the time being because we will have lessons separately for confessions. So in lesson number 24, we saw as to who could make admissions under sections 18, 19 and 20. In today's lesson, we will take this discussion a little further ahead. So with regard to the circumstances in which admissions can be made, we will have a look at section 21 in great detail because it's a very important provision relating to admissions. Section 22 deals with admissions as to documents, and we will deal with that later on when we study documentary evidence. So I will not deal with it in this video, but you can go ahead and read it by your own self. It will help you. Also, section 23, we will see it when we are discussing section 29. So in the video dealing with section 29, you can access that by clicking on the I button at the top right. We will deal with section 23 there. So we will not deal with 23 in this video. Also, what we will deal with in this video is the evidentiary value of an admission, which is given in section 31. So this lesson will focus primarily on section 21 and section 31. So in the previous lesson, we had seen the definition of an admission. An admission, we learnt, is a statement which suggests any inference as to a fact and issue or relevant fact, right? I'd also discussed as to what the meaning and significance of inference is, right? So let us say we have a statement, just to repeat, let us say we have a statement, okay? Whatever is clearly given in the statement is said to be expressly stated, okay? But when you draw something from this, when you draw something from it, then that thing is an inference. So you must remember, an inference is something which is not expressly stated. It is an implication that you draw from the statement, okay? So we learned that an admission is an inference that is drawn as to any fact and issue or relevant fact. And then we also saw that it has to satisfy certain conditions that are given hereinafter, which means it has to follow the conditions given after section 17. Now, you might remember that I have told you several times in the preceding videos that admissions are self-harming statements, right? I told you that admissions are self-harming statements. Now, have a look at the definition of admissions and tell me as to where in the definition of admission you can see that it is self-harming. Can you see any place, anything in this definition wherein you can infer that an admission requires to be self-harming? Because as far as as far as the statute is concerned, it says which suggests any inference. So an inference could be self-harming or it could be self-serving. So how did I say that an admission has to be self-harming? What was the basis of my saying that admissions are generally self-harming? Take a moment, try to find out by your own self. Think as to what the answer might be before you proceed into the lesson. So perhaps you might have guessed that the answer to this question here, as to where it is stated that they need to be self-harming, lies not in this particular definition or within the words given in section 17, but in the provisions that are hereinafter mentioned. That's why this is so important. The meaning of admissions is gathered not just from section 17, but also from the provisions that are mentioned after section 17. So we have already seen sections 18, 19 and 20 in the previous lesson, lesson number 24. And now we will look at section number 21. So when asked the question as to why admissions have to be self-harming, the answer lies in section 21. Let us have a look at section 21. This is the first part of section 21. It reads that admissions are relevant and may be proved as against the person who makes it. Likewise, you see the second part, it says that, but they cannot be proved on behalf of the person who makes them. So, when you say it can be proven only against the person who makes it, then this suggests that it is self-harming. Okay. And then it goes on to say that it cannot be made on behalf of the person. So it cannot be made on behalf of the person. That means it cannot be not be self-serving, right? So this principle is something that you get from section 21. Section 17 does not tell you that. Also, I want you to take notice of one thing at the very bottom of this here. Except in the following situations. Okay, except in the following cases, which means that here you have some exceptions. What are these exceptions? These are exceptional cases in which you can make self-serving admissions. Therefore, you might remember that I told you earlier that admissions are not always only self-harming. Sometimes they can be self-serving. So we will have a look at these exceptions as well. But before that, let us have a look at an illustration to understand the rule that is given here, and then we will go ahead and also look at the exceptions. Alright, let's have a look at the first illustration, illustration A. Make sure you pay attention because this is a little intricate. It's simple, but it requires you to pay attention. Okay, so you have A and B. A affirms that the deed is genuine and B says that it is forged. So A and B are in a dispute. Obviously, the dispute is over the deed. Okay. A suggests that the deed is genuine and B suggests that the deed is forged. Okay. So we know as to which side A and B are. Now, you can guess what is a self-serving statement for A. The self-serving statement is to say that it is genuine. The self-harming statement is to say that it is forged. Okay. Likewise, for B, what is the self-serving statement? The self-serving statement is to say it is forged. What is the self-harming statement? It is to say that the deed is genuine. Okay. So now that we have this understanding, let us look at the remaining part of the illustration. It says A may prove a statement by B that the deed is genuine. Okay. So suppose B makes a self-harming statement that the deed is genuine, then A can go ahead and prove that statement, which means he can give evidence for that. And B may prove a statement by A that the deed is forged, which means B can prove a self-harming statement by A and A can prove a self-harming statement by B. But A cannot prove a statement by himself that the deed is genuine, nor can B prove a statement by himself that the deed is forged, which means that these people cannot make self-serving statements. This is the rule that is contained in section 21, and therefore I said as a rule that admissions have to be self-harming. It's very important. Make sure you take your time to understand this illustration. It is very important for you to understand this concept and this section along with the illustration. So we have understood the rule contained in section 21, the rule being that admissions have to be self-harming. Now we will look at the three exceptions, right? So as you can see, there are three exceptions that are as follows. You can take a moment, pause the video and try to make some sense of these exceptions by your own self before you proceed with the lesson. So now let us look at this one by one, starting with the third exception. The third exception says that an admission may be proved by or on behalf of the person making it if it is relevant otherwise than as an admission. So what did we see? We mean to say here that if it is relevant otherwise than as an admission, then it is relevant. Let me remind you that we had discussed that a fact can be relevant under more than one section. We'd studied this when we were studying sections 6, 7, 8 and 9. So it is possible that something might be relevant under section 6 because it forms a part of the same transaction. It is also possible that it might be relevant under section 8 because it shows motive. Okay. It might also be relevant under section 11 because it is inconsistent with another fact and issue. So it's possible that a given fact can be relevant under more than one section. So what we are seeing here is that let us say there's a certain admission, okay? the admission is self-serving. So you have an admission which is self-serving. Now, ordinarily, a self-serving admission is not admissible, right? But suppose this self-serving admission is also relevant under some other section, right? If it is relevant under any other provision relating to relevancy, then it continues to remain relevant even if it is self-serving. So basically, if a self-serving statement, a self-serving admission is relevant under some other section, it continues to remain relevant regardless of the fact that it is a self-serving admission. Very simple, very straightforward. We can understand this better by looking at the illustration D, which deals with this point. Okay, so A is accused of receiving stolen goods, knowing them to be stolen. A offers to prove that he refused to sell them below their value. Let's think of it like this. A is accused of having some stolen goods. Let us say he had some stolen jewelry. Okay, the jewelry was maybe worth 50,000 rupees. Okay, now A is accused of being in possession of this stolen property. Now A offers to prove. A says that I had gone to a shop where he had tried to sell it for 50,000 rupees only. Now, how is this significant here? Well, this is where you need to draw an inference. If you've noticed, I emphasize the importance of the word inference. Let us say if A was actually someone who was a thief. You know that people in these markets sell things much cheaper. Maybe he would have wanted to sell that thing off for 20,000, right? Perhaps you're aware of the fact that there are these chor bazaars, the markets where these stolen items are sold. So when a person is selling it at its real price, at its actual market price, it becomes unlikely that he might have stolen it. Therefore, this is suggesting an inference, right? Go back and look at section 17. Here you can see that this statement suggests an inference as to a fact in issue or relevant fact. So in this case, it suggests the inference that since A was selling it at the market price, then he might not be the person who has stolen it. So it's suggesting an inference. Now, the question is, what kind of inference is it? Is it self-serving or is it self-harming? As you can see, in this case, it is a self-serving inference. It serves his purpose because it serves his interest. Now, in such a scenario, is this self-serving interest, is this self-serving admission of his admissible or not? Let's look ahead. If you look at the illustration, it tells you that A may prove these statements, though they are admissions, right? Because they are explanatory of conduct influenced by fact and issue. You see, if you remember section 9 also talks of rebutting an inference suggested by a fact in issue or relevant fact, right? So this statement of his, this fact here, this is relevant under section 9 as well. So what we just saw was that if a self-serving admission is relevant under some other provision, then it continues to remain relevant. So I hope you've understood the point. This thing is relevant both under section 17 and under section 9. Therefore, a self-serving admission can be admissible. Now let us have a look at the second exception. The second exception is simple. What it basically means is, let us say somebody has made an admission, okay, and that admission is self-serving, okay, but there is a conduct that accompanies it, okay. There is also some action that he does, and by means of that action, it appears that his admission is true, which means that the conduct makes it appear that its falsehood is improbable, which means that it is likely that it is true. So whenever there is a self-serving admission accompanied by conduct which makes the statement appear true, then in such a case also the admission, though self-serving, continues to remain admissible. Now we look at the first exception. Okay, so as you can see, it makes a reference to section 32. Now section 32 consists of 8 subsections which determine the cases in which a statement may be relevant because the person who's making the statement is either dead or cannot be found, or because it takes too much effort or expenses to bring that person to the court. Okay. In such a scenario, obviously, a third person has to make the statement, because if the maker of the statement is dead, or if he cannot be found, or if he cannot be brought to the court, then a third person has to be brought. So let us say there's something which would have been relevant if that person were dead, right? So let us say there's a statement that is made by a person A. Now this A is a third person. What the exception 1 is saying is, if the statement by A would have been relevant under section 32, if A were dead, then the statement made by A, even if it is self-serving, would continue to remain relevant as an admission. Okay. So what that basically means is, let us say there's a self-serving admission. Now, ordinarily self-serving admissions are not relevant, but if that statement, that self-serving admission, would have been relevant under section 32 if A were dead, then that self-serving admission is relevant. That is what we get from the first exception. Now that we know the rule contained in section 21 as well as the exceptions contained in it, let us look at what the evidentiary value of an admission is. Section 31 says that it is not conclusive proof, but it may estop. Conclusive proof, we know that section 4 tells you that there are three kinds of presumptions. The first is a may presume, then you have a shall presume, and then you have what is known as conclusive proof. Okay, so conclusive proof basically is something which is irrebuttable, which means that once one such conclusive proof is established, the court will not accept any evidence to the contrary. Okay, so what is the meaning of saying that it is not conclusive proof? Which means that, let us say A makes an admission. Okay, now what is the evidentiary value of this? If A makes an admission, does that mean that nothing can go against it now? That's not the point. That is not the case, because the statute tells you that it is not conclusive proof but merely estoppel. So looking deeper into section 31, we can see that admissions are not conclusive proof of the matters admitted, but they may operate as estoppels under the provisions hereinafter contained, which basically means the provisions given after 31. Now, how much after? Well, the provisions relating to estoppel are given in sections 115 to 117 of the Indian Evidence Act. So if you want, you can go and have a look at these provisions. But basically the point is that what is an estoppel? An estoppel is basically a principle of evidence, which basically means that, let us say somebody has made a certain kind of representation. He makes a statement. Now he is not permitted by law to retract it. He cannot go opposite to it, which basically means you cannot blow hot and then blow cold. You cannot make a statement and then deny the truth of it. So if you have made a statement, you will have to stick to it. You are estopped from denying the truth of a statement you have made. That basically is estoppel. With this, we've dealt with most of the provisions relating to admissions. I hope this lesson was of use to you. Thank you so much for your patience. Good day.